Good. क्या नाम है आपका?
So my name is Dhawal.
धवल. क्या मतलब होता है धवल का?
So it means pure.
And it is also a synonym for silver.
ओके. राइट. अपने बारे में और बताइए थोड़ा मुझे.
I was born and brought up in Lucknow, and I completed my schooling from City Montessori School, State and Rural Branch, Lucknow. And after that, I gave CLAT. I was selected for National University of Research, and I graduated in 2020. And since then, I have been preparing for judicial.
कब बने हैं NLUs ये?
Sir,
आपका कॉलेज
Sir, my college was established in 2008.
2008 और NLU कब बने?
Sir, they were included in NLUs later. Earlier, the universities existed. Like for Bangalore, it has been existing for 30-35 years now. Sir, but CLAT was introduced. I'm not able to remember the exact year.
मैं एक लॉ कॉलेज खोलना चाहता हूँ, क्या करना होगा मुझे? क्या लीगल नॉर्म्स फॉलो करने होंगे?
Law college building, sir. Sir,
आपकी अथॉरिटी कौन है जो रिकग्निशन देगी मुझे लॉ कॉलेज को?
sir, state government.
और कोई?
Sir, if it is a law college, then I think, sir, High Court. I'm not sure.
एक एसोसिएशन है, काउंसिल है, बार काउंसिल, बार काउंसिल ऑफ इंडिया. इसके बारे में बताइए मुझे, क्या होती है बार काउंसिल? कौन होता है BCI का चेयरमैन?
Sir, the chairman of Bar Council of India. Sir, I can tell the functioning of it, but I'm not able to remember how the chairman is.
कौन है? अच्छा अभी
Right. From 24 of any.
आपने तो रजिस्ट्रेशन कराया हो, AIB का एग्जाम दिया है आपने? ओके. क्या होता है AIB का एग्जाम? दिया नहीं लेकिन पता तो होगा ना?
Yes, sir. The already bar exam, if I give it, and then after that, I'll be eligible to appear outside my state as well. If I want to appear in court.
ओके. सबसे अच्छा सब्जेक्ट कौन सा है रेडी आपका?
Do I study all the subject, but if preference has to be given to one subject or more things, sir, I'll give it to CR.
CRPC. तो ठीक है, तो CRPC से ये पूछ लेंगे आपसे. मैं कॉन्स्टिट्यूशन पूछ सकता हूँ? तो मुझे आप 1 से लेकर 12 तक सारे आर्टिकल्स बता दो लाइन से.
Okay, sir. Article 1 states that India is a union of state.
ठीक है.
Sir, Article 2 states that Parliament can add into states. Parliament has be given the power to add new states.
ठीक है. प्रोसेस क्या है?
For Parliament.
So it is given under Section 3 that on the recommendation of the President, a bill can be introduced, and the bill has to also be sent to the state legislative assembly of the particular state on which area has to be reduced, increased, or name has to be changed. But it is only a format. But even if for the consultation, no consultation is received. Even after that, even if the consultation is not received, even then the bill can be passed, and the name, area, and or anything of the state can be changed, or a new state can be added.
अरे आगे बढ़ते हैं. 4.
The Article 4 tells that when a state has been name has been added, or the state has been added, then the changes will be made to Schedule 1 and Schedule 4 of
The Indian Constitution.
When 5.
So 5 tells about citizenship, that who shall be the citizen of India. The person who has domicile in India, and
Either he is currently a citizen of India.
इस हिसाब से तो आपको अपना फेवरेट कॉन्स्टिट्यूशन बोलना चाहिए था. चलिए आ जाइए सीधे 12 पे. 12 में वर्ड मेंशन अदर अथॉरिटीज. क्या मतलब है इसका?
so other authorities has not been defined anywhere. But sir, over a period of time, with a lot of case laws have been decided by the Supreme Court, where the definition of other authority has been formed.
ओके. कुछ किस लॉस के नाम बताइए.
Sir, for example, in the case of Shitty, well, I'm not able to remember the exact.
Is there
RD City
R.D. Shetty versus Airport Authority of India?
क्या डिसाइड हुआ था इसमें?
Sir, in this, it was still when the other authorities' interpretation was given that if an agency is an instrumentality of the state, then it will come under the definition of the other.
Very good. Very good. 13.
So 13 it gives us the right that if a law has been made, if a pre-constitutional law is there, then if it violates the fundamental right, then it will be void to that extent, and the parliament cannot make a law which violates the fundamental right. And if it makes, then it will be void to that extent that it violates the fundamental rights.
Amendment done under Article 368 come under the definition of law under Article 13.
No, sir.
As per Article 13, Clause 4, which was amended by the 24th Amendment, the amendment made under Article 368 doesn't come under the definition of law given under Article 30.
Pardon, please.
As per the amendment made by 24th Amendment, 13 Clause 4 was added under Article 13, which tells that when in the law that has been defined under Article 13 Clause 3, it does not include an amendment made under Article 360.
Very good. Judiciary को state माना जा सकता है
Sir,
under Article 12.
In with the Supreme Court case on that, it is a PR Antole case where it was told that since even the courts have the court cannot violate the fundamental right of a person, but the clarification was given in a recent case of I can say in 2011 or 2012, Riju Prasad Sharma versus State of Assam, wherein it was told if the courts are acting on the judicial side, then they are not a state. But when they are acting on the administrative side, then they are a state and they cannot violate a fundamental right of the person. Right. इसको आप खोलें.
हाँ, आर्टिकल 14 किसके किसके लिए है, किसके ऊपर अप्लाई होता है?
sir, all the persons.
क्या मतलब हुआ पर्सन्स का?
Persons include
So it includes citizens, not citizens with as
ओके, कंपनीज पर?
yes, sir. Even to the even companies and to the shareholders of the company that is also applicable.
ओके, अनरजिस्टर्ड फर्म? लीगल रीजनिंग से जवाब दीजिए. ऑब्जेक्टिव क्या है 14 का?
The objective of 14 is that that equality has to be provided to have an equal protection of laws.
Right. अब बताइए अनरजिस्टर्ड फर्म को मिलना चाहिए कि नहीं?
As per the, if I have to give a reasoning, I don't think it should have not gone in the state forms.
बेसिस क्या है रीजनिंग का आपकी?
Sir, I think even for a company fall under the definition.
अगर हमारा ऑब्जेक्टिव इक्वालिटी है तो हम इस बात में क्यों पढ़ेंगे कि रजिस्टर्ड है कि नहीं, जब हम इतने वाइडर एम्बेट पे हैं कि हम सिटीजन, एलियंस, कंपनी सबको दे रहे हैं इक्वालिटी की बात, तो हम इस बात पे क्यों पढ़ेंगे?
Again, Article 14 also tells about the reasonable classification. That if we have to, for instance, if a firm is unregistered, then equality there has to be some reasonable classification which can differentiate between a registered firm and a non-registered firm. So therefore, reasonable classification can be made, wherein all the laws that are applicable to other firms which are registered cannot be made applicable.
Right. What is the relation between 14, 15 and 16?
So Article 14 gives the general principle of equality, and Article 15 and 16 are a facet of Article 14, which tells the specific instances of equality. Sir.
Very good, sir.
What is Section 133 of CRPC? Sir, Section 133 of CRPC is it relates to public nuisance, that the executive magistrate has the power to when an application is made to him, or he can remove a nuisance in a society or locality within his jurisdiction. What kind of order will be passed by the executive magistrate? So, for example, so can I tell it by an example? Yeah, please. So, for example, if a well or a building is collapsing, or if there is a company that is producing hazardous or toxic substances, then in that case, if an application is made to the executive magistrate, he'll order to show cause to that person or to that company to show cause why it should not be removed. And if after the show cause he considers that it is really causing a hazard to the society or the locality, then he can remove that. You are telling me the provisions. I am asking you about the nature of order. What kind of order? Will it be an order? Sir, it's an executive order. No. Will it be a final order or will it be a conditional order? Sir, first it will be a conditional order. Then after the state show cause and everything that has been after he has shown cause, then after that, if the magistrate still considers that it is hazardous, then he can issue a final order. Okay. What is the difference between further investigation and reinvestigation? Sir, further investigation the provision for further investigation has been provided under Section 173, Clause 8 of CRPC that police, even after submitting the charge sheet, can further investigate the case and submit the additional supplementary charge sheet after that. Even the magistrate, via Supreme Court judgments, has been given the power to order further investigation. But reinvestigation is something which a magistrate cannot order and cannot order for an investigation.
Then who will order for reinvestigation?
Sir, if an investigation has to be ordered, then inherent powers of the Supreme Court under Section 482 can be...
Who are the powers of the
High Court, sir.
You used the word charge sheet.
Yes.
Has this term been used in CRPC?
Yes, sir, it has been in CRPC.
It have to be very specific. Has this term been used in under Section 173? And what word has been used?
So, police.
Then what is the difference between police report and charge sheet?
Sir, when a police submits after investigation, when the police submits a report to the magistrate, it can be two ways. One, that the investigation has been completed and the case has been made out against the accused, then it is a charge sheet. But if the police, then it is for the charge sheet. But if the case is not being made and they think that the accused is not victim, there is no offence has been made out, then they submit a closed report.
Okay. What is Section 464 of CRPC?
Sir, as far as I can remember, Section 464 of CRPC gives power to appellate and revisional courts to order or add charge if during the trial it has not been added.
Does it talk about irregularity in framing of charges?
Yes.
What are the key differences between complaint and first information report?
Sir, a first information report is made to an police officer, and the complaint is made to a magistrate. And the first information report is related to a cognizable offence. Complaint can be relating to a cognizable as well as not cognizable offence. Further, sir, for the procedure after FIR is different. For after FIR, the procedure is different. That is, the police will investigate as per 161 statement, 164 statements, and will submit a charge sheet. But sir, for complaint, it is different. Magistrate will first take the cognizance of the complaint, then it will examine the complaint under Section 200, then the process of 200, and then the process will be issued under Section 204.
You used the term cognizance.
Yes, sir.
What is it? Has this been defined in the code?
Sir, the word cognizance has not been defined under CRPC, but Supreme Court has over a period of time had in various Supreme Court judgments that cognizance is when a case, when a police report or when a complaint is before the magistrate, when it applies a judicial mind, magistrate applies a judicial mind to see whether the case is made or not, or whether to further proceed in the case or not. That is to say, taking of cognizance.
What if a magistrate who is not empowered to take cognizance seeks cognizance? What will be the consequences under Section 190, Clause 1, Subclause A, Subclause B, and Subclause C?
So if a magistrate takes cognizance under Subclause 1, under A, that is a complaint, and it is 190 Clause B, that is on a police report, then if the magistrate has taken cognizance in good faith, then the proceedings will not be void. But if the magistrate has taken cognizance who moto or other reason on a complaint under Section 190 Clause C, then the proceedings will be void as per Section 464.
Vitiated. Proceeding will vitiate.
Sir, what is caveat? Caveat has been defined, has not been defined, but the procedure has been given. Caveat in the literal sense means a warning. And sir, it is the provision for that has been given at the Section 140 key day of sympathy.
What is it?
Sir, it does that. It's sir, I'm not able to recall the exact provision, but sir, as per the general principle is that when a application or a case is filed before a court, then the person may submit a caveat to the court that in case an application is filed, then he must be informed regarding that application, and that caveat application is also forwarded to the person who will be filing the application, sir. so that in case an application is filed, the person is made aware that a case has been filed before on the court.
डीप डिग्री क्या होती है?
Sir, deemed degree is a fiction created by law. It is not a degree, but a fiction created by law. Sir, or for example, or it has been defined under Section 2, Clause 2 of CBC, and Order 7, Rule 11 is a deemed degree. Section 144 of CBC is a deemed degree, and it has been included in Section 2.
Receipt.
So I'm not able to reply.
ट्रांसफर प्रॉपर्टी एक्ट में
Yes, sir.
एक्सीडेंट क्लेम
Yes, sir.
इसके बारे में बताइए.
Sir, actionable claim is a claim over an unsecured debt or any right over a movable property which courts recognize. And sir, the procedure for that has been laid down from section 130 to 136 of transfer of property. And
मॉनिटराइजेशन चार्ज में डिफरेंस क्या होता है?
sir, mortgage, there is an interest created over a property, and for a loan advanced or for a money that has been taken, the mortgage is on the basis of the operation of the parties, but charge can be created by law as well over a property. For example, in case of sale, if the buyer is not paying the remaining amount, then the seller has a charge over it. And sir, in charge in the section related, it is specifically being written that charge is not a mortgage. So,
अनलॉफुल असेंबली.
so unlawful assembly has been defined in a section 144 of IPC, that when five or more persons commit an offense, or they plan to commit an offense of waging war against the state, or any offense against the state, of criminal mischief or trespass or cheating, and other offences have been given which I am not able to recall.
कब हुआ था प्रीलिम्स का एग्जाम आपका?
Sir, on 12th February 2020.
और कितने मार्क्स के होता है प्रीलिम्स?
Sir, 450 marks.
जनरल स्टडीज में जीएस में कितने मार्क्स होते हैं?
Sir,
GS is of 150 marks.
ओके. और लॉ?
Law is of, sir, 300 marks.
कुछ
आपने अभी अनलॉफुल असेंबली का सेक्शन बताया, उसको रिविजिट करना चाहोगे? किस सेक्शन में डिफाइंड है अनलॉफुल असेंबली?
So as far as I can remember, it has been defined in the section 141.
अच्छा, अभी शायद
144 बोला था.
आपने 144 कह दिया था शायद फ्लोर. What is the difference between common intention and common action?
So common intention is when two or more people agree to commit an offense, and they agree to or an actionable wrong, and their common intention is to do an offense. But so common object is that the intention may be different of people, but they want to achieve a particular goal. Intention here may be different. For example, in common intention, the intention of both the person may be to kill a person, but for common object, the intention may be different. For one person, for common object, the object is same, to kill a person, but their intention might be different. One might be wording other intention, another person might be wording other intention.
अच्छा, और फिर difference?
Sir, common intention has been defined under section 34 of IPC, and common object not being defined under section 149 of IPC, the provision for common object has been defined.
Which of the two is a substantive offense, or are both of them substantive offenses?
So common object is a substantive offense, but common intention is not a substantive offense.
Okay. What is the distance between common intention and similarity? And what are the rules regarding each other?
So for common intention, it is 34 of IPC. But sir, as far as similar intention is concerned, sir, I'm not able to recall any provision for that. But sir, common intention has been specifically made that if it is added along with another offense, that it is then common intention can be proved. But similar intention has not been defined in IPC.
Yeah, the word similar intention has not been defined, but can it be deduced from any one of the provisions?
So I'm not able to read that.
Okay. एक और बात, there is a term called voluntarily. Where has this been defined in IPC?
So as far as I can recall, the voluntary term has been defined under Section 39 of IPC.
What are the key ingredients? Voluntarily.
When any person has is that anything with an intention or knowledge, or he has reason to believe that then it is said to be that he has done the offense or the act voluntarily.
And what is the reason to believe?
I mean, yes. So reason to believe has been again defined in IPC. I am not able to recall the exact section. Reason to believe, sir, when person believes that thing to be true and not otherwise.
So think of
फीडबैक इंटर किए थे ना, तो तुम इतने ही काबिल नहीं दिख रहे थे जितने अभी हो. हाँ, मतलब तुम्हारा जो फर्स्ट इम्प्रेशन था वो बहुत बहुत अच्छा नहीं था.
हाँ
अब वो बिकॉज ऑफ हेयर स्टाइल.
हाँ ये
हाँ नहीं, बस हम लोग का ये ऑब्जेक्टिव, हम लोग तो मॉक पे है. वहाँ पे क्या रहेगा,
वहाँ पे
क्या हाँ. और क्या तुम पहनते हो चश्मे वगैरह कुछ? नहीं. अच्छा, बस एक चीज थी ना, ऑल्दो तुमसे बात करने के बाद तो ये सब चीजें मतलब धीरे धीरे तो बहुत सीरियस दिखने लगे, और आखिरी आते आते सब कुछ सही हो गया. तो बट जब शो में इंटर किए थे ना, तो एकदम जैसे ना बच्चे होते हैं कि बस किसी तरह हो गया है, बहुत विशेष मतलब है नहीं. तो वैसा वाला सीन आया था. बट हाँ, एक ये. दूसरा मेरा सजेशन है, बहुत तेज हो,
बोल स्पीड फास्ट.
हाँ बहुत फास्ट है.
फास्ट
वो मतलब मैंने भी लिखा हुआ है, आपने भी लिखा हुआ है, बहुत तेज है. थोड़ा सा क्या वो स्लो हो सकती है, मतलब लाइक कभी कभी देखो ऐसा होता नहीं है, हर व्यक्ति की पोजीशन उसके लीगल नॉलेज पे मैटर नहीं करती. बोर्ड में जो सामने बैठे हुए हैं, जरूरी नहीं है कि वो इतने ही लीगली नॉलेज होल्ड करते हो, और उन्हें अगर बात समझ में नहीं आएगी तो वही कतई नहीं मानेंगे कि मुझे नहीं समझ में आई. वो ये कहेंगे कि तुम मुझे समझा नहीं पा रही. यही जनरल रूल है. आपको थोड़ा सा स्लो करना ही होगा इसको. जैसे मैं समझा रहा हूँ ना आपको, थोड़ा सा इससे तेज आप ऐसे ट्राई करिएगा, थोड़ा सा स्लो रहिए. ऐसा लग रहा है कि आपके अंदर सब भरा हो और आप जल्दी से निकल के आगे बढ़ना चाहते हैं, ये अवॉइड होना चाहिए. एक पर्टिकुलर फेस एक्सप्रेशन है आपका, आप आंसर देने के बाद इंतजार करते हो शाबाशी का. ये वाला आपने महसूस किया सर? अभी मैं आपको रिकॉर्डिंग दिखाऊंगा तो आप देखिएगा, आप ये करते हो सर, बार बार करते हो, हर बार आंसर के बाद आप वेट करते हो जो अगले क्वेश्चन, उसमें आप ये दोनों लिप्स को दबा देते हो अंदर. ये थोड़ा सा नेगेटिव साउंड कर रहा है. बस सब कुछ बहुत अच्छा है, कोई नहीं. अच्छा, BCI, AIB, सुप्रीम कोर्ट, हाई कोर्ट, इनके जजेस कौन है, अभी कौन है, BCI का चेयरमैन कौन है, इनको थोड़ा पढ़ लीजिएगा. नॉर्मल बार काउंसिल वाले लोगों को ही बैठा लेते इलाहाबाद से बुला के, ठीक है. तो आप इस थोड़ा सा पढ़ लीजिएगा, थोड़ा अच्छा साउंड करेगा. कोई बार आपको सच में इंस्टीट्यूट
For the time, thank you for this is nice to be all the best. I mean, sir, से बात सेंगे फिर एक बार वो ग्रूमिंग पे थोड़ा ध्यान दे सकते.
हाँ बहुत जरूरी है. हाँ,
जो आपने जो बोला कि मुझे भी थोड़ा रियलाइज हुआ कि हाँ शायद एक्सपेक्ट कि हाँ मैंने अच्छा आंसर किया, तो रिएक्शन आई वेट फॉर द रिएक्शन.
थोड़ा सा रिएक्शन का वेट करना अच्छी चीज़ है. वहाँ पे जैसे अभी आप हो, ये ठीक है, बट वो जो लिप्स वाला आप एक्टिविटी करते हैं ना, एक्सप्रेशन वो अच्छा नहीं साउंड कर रहा है, थोड़ा सा बहुत चाइल्डिश साउंड कर रहा है ना. बाकी हाँ प्लीज
because ये आप जो बैठते हो तो आप दोनों बटन्स खोल सकते हो, हाँ बहुत कंफर्टेबली पे बैठ सकते हो, क्योंकि बहुत टाइम मिलता है यार ये सब करने. तो एकदम कंफर्टेबल कि दोनों हाथ पे लाप पे रख के बैठ सकते हो, या दोनों हाथ
मैंने लैब पे रख के ट्राई किया, बट आई थिंक सर
जिसमें आप कंफर्टेबल
कंट्रोल्स माय हैंड्स.
हाँ जिसमें आप कंफर्टेबल, क्योंकि लॉन्ग रन अगर इंटरव्यू चलता है आप आंसर्स करते जाते हो तो आपको उतने टाइम के लिए बैठना है. जैसे भी आप कंफर्टेबल हो आप उसमें रख के बैठ सकते हो, पूरा टाइम है, देन रिलैक्स होके आप आंसर।
क्या हम लोग चश्मा लगवा सकते हैं इनको? अगर ये आदत है, कोई आदत मतलब कभी लगाए कभी नहीं लगाए, कभी नहीं तो है। हाँ। तो वहाँ इसकी वजह से नहीं, मतलब ऐसा लगता है जैसे तुम चश्मा लगाओगे तो और अच्छे दिखोगे, मतलब और सीरियस दिखोगे, तो ये एक हो सकता है। बट अगर नहीं लगाते तो फिर नहीं, मतलब फिर छोड़ दो, ठीक है। बट बस ये तुम्हारा एक है ना कि खूब स्मार्ट बन करना और थोड़ा हारी ये सब सही करके। कब है तुम्हारा डेट, क्या है? 20 बस लास्ट। नहीं नहीं, बहुत बेनिफिट मिलते हैं इसके।